First things that we consider.
Alternatives may include a durable power of attorney, patient advocate designation, representative payee for Social Security, or community services to help with activities of daily living.
So in both guardianship and conservatorship petitions, these are tools of the last resort for helping the person. We look for other things to do first before we impose a guardianship or conservatorship.
She does object to the appointment of a guardian.
If the individual objects to having a guardian or conservator, or if otherwise indicated, he or she may hire an attorney, or the judge will appoint an attorney to represent the person in court. The contested case will be set for hearing. The reason for the guardianship or conservatorship must then be shown by clear and convincing evidence presented in court.
If there's no objection by the person, then usually the guardian ad litem takes a few more steps to investigate allegations individually to find out if this person truly is incapacitated and meets the legal definition of incapacity, and whether or not the person who has been requested to be appointed as guardian is suitable to serve. If there are family members who have been involved with the person's life, we always try to talk to them. Then sometimes it's necessary to talk to the doctors and social workers that may have been involved in the case, look at the medical records in order to make an independent decision.
If the petition is for conservatorship, the focus of the investigation will be on the need to protect the person's assets, that is, their money and property.
So it is my recommendation that somebody who is closer by...
The guardian ad litem does not make a decision about the case, but does make a recommendation to the court. If the judge decides that the person is not able to make informed decisions on his or her own behalf and finds that you should have that responsibility, you will receive letters of authority. These are legal documents that tell if you have full or limited authority and the types of decisions you can make for your ward. They also list reporting duties and may list visitation requirements.
There's also a paper he would like for you to sign indicating you accept your appointment.
You will be asked to sign an acceptance of appointment. You then have what is called a fiduciary duty, which means you are in a position of trust to act in your ward's behalf.
Fiduciary is in the best interest of the person that you're helping. It's setting aside your own best interests and meeting the needs of the individual instead.
What do you need? You mean goals?
The guardian, by law, needs to ask the ward what they want, and to the extent that person is capable of participating in the decision, listen to them and try to do what the ward asks them to do.
Even if it is not what you would do for yourself under the circumstances, follow the ward's wishes as long as doing so does not compromise the ward's well-being.
When we start talking about time, it can be very, very time consuming, and especially if there's some medical issues, they're going to call you at 8 o'clock in the evening or 2 o'clock in the morning and wanting to know that, hey, we need permission or we need you here, and we have to deal with those issues.
It disrupts the workday. It disrupts weekends. I've resolved myself to say, well, it might not get any better. This might be how it goes for the rest of his or my life. And it does affect your own family. If you spoke with my husband, he would tell you how difficult it is because he doesn't see that there's any appreciation. It's a very thankless job.
Your extended family, everybody has to be empathetic to that and know that that's part of what the job is. So again, it's more than a job. It's a way of life.
You have to remember that illnesses take a life of their own, and they start out one way and they evolve, and you don't know quite what the end result is going to be, but you have to be prepared to go through the different stages. Not all of them are pleasant.
It is amazing when you have to account for every penny and provide an annual accounting that has to balance to the penny. How many things there are that you have to account for. There's bank statements, there's checks, there's receipts for everything you pay for.
And that's what usually happens with guardians. They find out how much work that they have to do, and they're overwhelmed. how much paperwork they have to do, and they, again, are overwhelmed.
And you're going to be asked to do things, and you have to be prepared to do them. And if you can't do them, don't take the job on.
It is important to remember that even after appointment of a guardian and conservator, the ward still retains some rights. Among them are:
Well, they have the right to seek an attorney. They have the right to have the court periodically review the guardianship or conservatorship itself to make sure that that's still an appropriate measure.
the court will continue to monitor the case. By law, a guardianship must be reviewed every 3 years. The court may at any time appoint a guardian ad litem to investigate a matter.
Does not have an arrest record.
I can see there's a lot of hostility between the two of them. That's probably
If a guardian has made a decision to put the ward in a particular nursing home and other family members are objecting and raise concerns about that, the court may appoint a guardian ad litem to review that decision and make a recommendation. With a conservatorship, the court might appoint a guardian ad litem to review how the conservator has been handling the finances and whether or not the money has been being used to benefit the protected individual.
On a daily basis, we take care of Brett by staffing 9 nurses and 1 assistant to take care of him. And you know, once you get into this, we've been into this 16 years, I guess it is our norm.
I think it's in Brett's best interest to have the court oversee everything, and we haven't had a problem with the court. They've been very good. But I think also from the angle that it's a security thing for us, that we can't have somebody saying that, oh, you added a pool onto your house with Brett's money.
Once a year, guardians and conservators must file reports and/or accounts to let the court know what has been happening with the ward and his or her money.
As far as working with the court is nothing to be afraid of. It's actually a great asset. So they have a lot of knowledge on different programs, on different techniques. They do have documents and reference books and things like that that would help any guardian as they're trying to make decisions for placement and social needs and educational needs and training needs.
In some cases, the court might change an appointment. For example, if there is a good reason for a guardian or conservator to resign, or if the guardian or conservator does not fulfill responsibilities or misuses authority. A ward also has the right to ask the court to change or remove a guardian or conservator. Upon the death of the ward, you must notify the court immediately, and your authority as guardian and/or conservator will end.
Another way for a guardianship to be terminated is if the person regains enough that they are now competent. And theoretically, acting in the role of guardian, that's kind of our job. Our job is to try and get them back to the point of well-being so that they don't need us anymore.
That was the case with brothers John and Jim. 17 years ago, Jim suffered a closed head injury. John was guardian and conservator, helping his brother through years of therapy and rehabilitation until Jim regained the ability to care for himself and his own finances.
As he thought and I thought that I could do it, with the understanding if I had any problems, I could always come back and get information from him. Then I just eased into doing all the things that I did before I was hurt. But it wasn't just an instant thing, here you go. We kind of eased into it, with his help and all, and it worked really good.
It's not a fun job, but it's something that really needs to be done. You really got to try to help when you can. So, but that'd be my biggest thing, is just don't give up and don't be afraid to ask questions.
He's a friend. He's strength. He's encouragement, and he helps me make wise decisions when I don't make the right wise decisions.
It makes me feel good that I'm doing my share.
There's been many, many benefits. It's the most interesting, fascinating job I've ever done, and I hope to do it for as long as I plan to work.
I'm mom. My job is to take care of my son, and I just do it without any questions asked.
You know, if I can help one person understand that it's important and that those loved ones do know you're there.
Our philosophy as a family has been just to make his life as good as we can and improve the quality of care that he has to the best of our ability.
He knows that I love him, and he knows that I'm working in his best interest.
And that's the only way this thing really ever works.
Bye.